Hi there, John Crotts at King Law. I'm an estate planning attorney, and I'm going to talk to you a little bit about wills versus trusts. What are each of those, and when might you need one versus the other? So a will, of course, is simply a document that describes how you want to leave your property when you die. It only takes effect when you die, and it's only valid when the will is formally probated with the court. So that is simply a process when your executor, which is that responsible person that you're going to name in your will, takes the will to the courthouse and has it formally filed and approved by the court so that the heirs can inherit the property through the will. This is something we think everyone should have. Regardless of your age, your net worth, or other circumstances, and is something that is vital for any estate plan. A trust, on the other hand, is a document that allows you, similar to a will, to establish who your beneficiaries are, but it only covers what assets you put into the trust. So a trust can be very narrow with respect to the money or the property or the assets that the trust owns, or it can be very broad and very general and include the majority, if not all, of your assets. One of the more common trusts that we draft is something called a revocable living trust. The primary purpose of a revocable living trust is to avoid probate. We can talk more detailed at another time on the probate process, but probate can be a cumbersome and difficult process. In many cases, can take a year or more to complete probate and get the court to approve everything after you go through all the creditor notices and the inventories and the accountings. It can be a very difficult and expensive process. Oftentimes, individuals have to hire attorneys, accountants, or other professionals to help them get through that. So having a trust or a revocable living trust allows an individual to put some or all of their assets into this trust, and whatever the trust owns upon death, the trustee, which is the responsible person that's going to handle the trust's affairs, the trustee upon your death can divide up your property according to the instructions in the trust, similar to what an executor would do in a will. But whatever the trust owns doesn't have to go through that probate process. The heirs or the beneficiaries can get their property much more quickly without any court supervision and oversight or delay. There's several different types of trust in terms of the legal mechanics of it. There's charitable trusts. There's trusts for the benefit of minors, spendthrift trusts, a Medicaid asset protection trust, irrevocable life insurance trusts. I don't want to give you an exhaustive presentation on each of the different types, but just to let you know that there are different variations for different purposes. In fact, a will itself can contain a trust inside the will. That's what we call a testamentary trust. And one of the more common types of trusts that we do for clients that have minor children is a testamentary trust that says, in the event I have children that are 18 years of age or younger when I die, I want my executor, instead of just giving a windfall to my kids at an early age, we're going to hold their share in trust until they reach a more responsible age, whether that's 21 or 25. You've got flexibility in when and how they would get that money and in who would oversee that money as a trustee for their benefit. So that is a very important type of trust that we include in most of the wills that we draft. Even for even if you don't have minor children, you may have grandchildren. You may have a situation where you thought an older individual is going to inherit from you, and perhaps they predecease you and they have younger children, and you want to make sure that those children don't necessarily get that money before they're responsible enough to manage it. So some good trust provisions in your will help avoid some unintended consequences there. If you'd like more information about some of the different trusts that we draft, or just want to have a conversation and say, hey, which is best for my situation based on my age and all my goals and objectives and my financial situation, there's no cookie cutter approach to this. It needs to be a one-on-one conversation, and we can do a customized estate plan for you. So please call us and schedule a consultation, and we can have a in-depth discussion about what would be best for you and your estate plan.